No.
All right. Just so you know.
Okay. Wonder if anyone.
You don't want the world to hear.
Yeah, that's right. Wonder if anyone tunes in early just in case.
I can check.
Oh, can you grab the iPad real quick and just mute the desk mics? I can already hear Hunter.
I thought I did.
Sure.
I'm not sure. What can you do?
Oh, well, it sounded like Hunter was talking right into the microphone a minute ago. I don't know, maybe it's just that good. We'll see. All right. Testing. Judge microphone 1. Can you check the camera? Well, you're not in yet? Oh, man.
I mean, there'll be a 45-second delay anyway.
There it is. All right. And while I'm over here, can you just check the camera? Can you check the camera to make sure I'm not cut off? Yeah, that's what I was afraid of. All right.
Yeah, well, you were okay, but...
Okay. Here, we'll get both ends and then we'll do the mic check. All right. How about this end?
Oh, yeah.
Yeah, just while I'm back here.
Yeah.
All right, beautiful.
So you want to, yeah, that's all.
Yeah. First one sounds pretty good.
Yep.
We have, oh my, almost sank into that. Judge microphone 2. Testing Justice Douglas. Testing Justice microphone number 3. Number 3. Testing Judge microphone 4. Judge microphone 4. Judge microphone number 5. We have number 5. Oh, that's gonna be, might have to turn that down a little bit on the stream. I can see it approaching the red line from the computer.
Yes, they're on the...
OBS, just a hair. Just a hair. Yeah, like it'll probably be fine for most of it, but until the inevitable happens, Oh, did that get turned back up? Because we had that down to nothing.
Yeah, but I put in...
Oh, that's right, we did the other one. I forgot about that, okay. Okay, yep. Perfect. And Judge microphone 7. Even that didn't sound that bad. Sorry, say that one more time. Speaking to 7? Yep. Oh, Judge microphone 7. Looking okay? We're not redlining?
Well, we're really looking at OBS.
Oh, still, huh? Okay.
Yeah, I'm just turning it down. Can you...
Yeah.
Sorry, start again. Go. You can go from 7 to 1. No.
Do it in order. All right, oh my. We'll just fall into that every time. Judge microphone 1. Testing Judge microphone 1.
Maybe a little higher than you beat. Okay. Next, one more time.
Oh. Judge microphone 1. Judge microphone 1. Okay. Not bad. All right. Judge microphone 2. One more time. There's the trash can. Oh, goodness. Judge microphone 3. We have Judge microphone 3. Oh, no. Judge microphone 4. Judge microphone 4. Oh, I didn't even hear myself kick the trash can. That's great. Judge microphone 5. If you want to hit the microphone earlier, like we wouldn't get the jump of feedback like we used to. Maybe that's just in my head. I don't know. Judge microphone 6. It does seem a lot more consistent. I can kind of see what you were saying yesterday.
Yeah, about the process.
Yeah, it sounds a ton better. And it still sounds pretty clear. All right, even turning it down, I think we're in good shape.
Well, in the room at the back.
No, I got my headphones on. Yeah.
And I think there's less background noise now.
That's my impression. I would have to like crank the volume and blow my ears out to really tell. But yeah, no, it sounds a lot better.
There's some background noise. Let's try E level here.
Yeah, I was gonna say. I think we're just gonna be kind of stuck with that, to be honest.
The background noise? Yeah.
And it's subtle enough where, like, again, unless you have it really dying and you have headphones on, I don't think it's really gonna. I don't know.
We're not selling albums or anything.
No, yeah, exactly. We're pretty explicit. Yeah. All right. I'm gonna come back around.
Okay. So lavalier microphone 1 sounds a little loud here, doesn't it?
Yeah,
Or at least back here.
I was gonna say, so you want to go to the well, because I think that's going to affect how we're testing it.
Well, yeah, but also, so this is clipping. So I'm gonna
Turn the gain down? Yeah.
turn the gain down some.
It's really pronounced that.
It's too. So I'm gonna, in the control for the bench speaker, turn it down. I mean, obviously they need to hear it.
I mean, that's what I'm saying, is if you walk into the well, I think it's let me come in.
Yep, no, I got it. Stay there, actually.
All right.
Because I want you to hear what it sounds like to the judges.
Right.
So this is where the attorney will be. Can you hear me
From here, very clearly.
very clearly? So you might just, that's still. So if I turn it up a little bit, is that too much? That's too much, isn't it? Well, through the speakers.
One thing at a time. You sound far away on the stream. That's the issue.
Yeah.
In the room, you sound far. You sound far away on the stream. Try putting it higher, maybe.
No, I don't think that'll
Yeah, it might not.
do it, but, so take the headphones out for a minute. I want to make sure this sounds okay
You just want to do it here for now?
from the bench.
Okay. Start from here.
So, yeah,
All right.
so this is still clipping, actually. Testing, 1, 2, yeah. I don't know why, so I'm gonna turn that gain down a little bit. Let's see if that works.
It sounds clear from up here, like it's
so
it is pretty
why is
crisp.
that clipping? Testing.
Did the mic head get unscrewed a little bit again? Is that vibrating?
I don't think so, but I wonder if I'm jarring it or something. No, so, hold on.
It's when you were moving. That's when we got
You
that.
say it's not doing it by itself.
No, it's
So
responding.
when does it do it?
You
Oh,
just
so
breathe
I
down.
breathe into
When you're
it.
looking down and breathing on it, yeah.
So
It's just sensitive. So
if I don't look down and I just do this, then it's fine.
yeah, that sounds pretty good.
So we just, it just, I don't know if there's anything we can do about that.
I think you just got to turn it down in the courtroom, and we'll just have to turn it up on stream.
Down further.
Yeah.
Well, I'm worried about the actual input clipping because it might, at least on the stream,
Yeah.
create, cut it off.
Gotcha.
Because when it clips, it stops all sound.
Sorry, I see what you're saying.
But I think this is okay now.
Okay.
So, sound okay from there?
Yeah.
It does.
Oh yeah.
so you can hear me loud and clear from there.
Yeah.
Does it sound like it's coming out of the speakers there?
Yeah. Oh, you can hear it. It's very clear, like, especially less so from the sides, but like the chief is gonna like.
Yeah, so there are 3 speakers in there. They're not super to the side, so. But from the side, I assume you can hear me okay.
Oh yeah. From the side, you sound great.
Okay.
From the
And
middle, I can hear a little more feedback. You sounded far away. It's very clear, like especially less so from the sides, but like even me talking back here sounds more clear than the lower end.
Yeah, that's weird.
You sounded far away.
So, I gotta find out which. So I thought he said. So I'm going to turn that up. And testing 1, 2, 3, 4. Testing 1, 2, 3, 4. Let's see.
Oh.
Still sounds far away.
It sounds far away, and like when that's on, there's a significant more amount of background noise, I think.
Yeah, 'cause if I mute this.
No, I can still hear that. Okay, so that I don't think that's the
where
one.
noise coming from though.
No clue. It's
Kind of like the squeaking.
yeah, because you can't hear it at all in the courtroom. Like
So.
we might have to turn like the main volume down. I don't know. Or well,
I'm
no,
gonna
'cause it
mute
sounds
everything
okay.
and just maybe one by one try to figure out.
Well, it's also 9 o'clock. We got 30 minutes. You can still hear that.
No, so I didn't.
Yeah, I was going to say, you still have something after.
You know what? I think. Goo. Hang on. Just want to test something.
So this is still.
Yeah, so hold on. Yeah, so he made this so that where is he leaving from?
All right, well, this is going to be a simple solution.
Well,
See, these back ones were muted. Those weren't. And now the ring is gone.
is it?
Oh, yeah. It was these. I don't think they were actually muted.
All right, so I gotta figure out.
So what mics do you still have active?
Well, it depends. So, on the main, can you hear me now through? Is it coming out? The main speakers? I don't think so. No, it's not. Okay.
Something was, it's just that. Here you go. You're a lot clearer, like so.
Yeah, no, I know it is. Well, but it's muted. So testing 1, 2, 3, 4, right? So that's. So testing 1, 2, 3, 4, 5. So the problem is, yeah, the different outputs. I got to remember what he said for what that XLR is sharing. Still sound far away. What?
This was getting picked up. I don't know what that is, but.
Well, so, yeah, so actually all of those subs can be off. It shouldn't, because it's not showing that there's any signal. So testing 1, 2, 3, 4, 5. Testing 1, 2, 3, 4, 5. So that's the main. It shouldn't be on the judges. Testing. So that's the witness one. Oh, so these should not be going to those speakers. That might be part of the noise problem. So let's see. There's nothing coming out here now. But if I do this, yeah, okay. So that has to be down. So that's good on that. Does this sound any different? Testing 1, 2, 3, 4. And there's still the ringing in the background. So, testing. Can we just try the podium microphone for now? I may have to figure this out during lunch.
Where did you put that?
Should be. Yeah. All right, so I'm going to turn this off. So testing, oops, I think I muted it. Yeah. Testing 1, 2, 3, 4, 5, 6, 7, 8, podium. Testing podium 1, 2, 3, 4.
I can see you getting picked on the stream. I don't hear you. Are you still here?
Testing 1, 2, 3, 4. Testing 1, 2, 3, 4.
There you go.
Well, yeah, but so you're not.
No, I can hear you. Yeah, I can hear you.
You can. Okay. Sorry. Testing 1, 2, 3, 4. It's not. It's not that high. Testing 1, 2, 3, 4. Testing. Oh, hold on. Oh, that's witness. So testing 1, 2, 3, 4. How does that sound?
Far away.
It does, huh?
Well, we'll see in a minute, I guess.
So testing 1, 2, 3, 4. Testing 1, 2, 3, 4. That might make the difference. Does that sound better?
Yeah.
Testing 1, 2, 3, 4.
Oh, yeah.
Okay, so I wonder, let me try.
Yeah, we should just.
Hold on, I'm going to try this again. So now the podium is muted to that, but not to the main. So, testing lavalier 1. 1, 2, 3, 4, 5, 6, 7, 8. Does that sound any better? Sound any better? Testing 1, 2, 3, 4, 5, 6, 7, 8. Lavalier 1.
Yeah.
I mean,
Sounds okay.
does it?
Yeah.
So better than it was before?
Yeah.
Not as far away. I wonder if. Oh.
Yeah. That's fine.
Testing 1, 2, 3, 4. 5, 6, 7, 8.
Yeah. I think that's a little better. I think
Okay.
use the podium, like if we're trying to mess around with using both, that's.
Yeah, so the other thing I want to make sure I need to go get my notes from yesterday, I think. Well, so can you tell, let me do this.
Yeah, so the other thing I want to make sure, I need to go get my notes on this.
So on this and there is this.
And then if I turn it down, it doesn't make any difference there, does it? Testing,
Testing. So then the question is, that's still coming out there?
Yeah, it's I'll see it that way.
so testing. 1, 2, 3, 4. So testing. Sounds better, yeah.
Is that from this?
Sounded fine earlier when we weren't using them, so.
This is squeaking's going away.
Yeah.
So, again, I want to test something here. So this shouldn't, I don't think, be coming out of or really showing a signal on either OBS or the USB. Do you see it?
See something?
Now let's see.
Wait, you can't pick it up.
Is that more?
More
No, more on OBS. So is there a difference between, hold on. Difference between this and this.
A little bit, I think.
So how about between this? No.
What?
Are you listening to the stream? Are you listening to the stream?
Yeah.
Okay, is the podium well?
Yeah, you can hear it.
Okay, so this is coming out there?
Yeah.
All right, so we'll use this for now.
so that's also coming out the bench speakers, right? So, all right. Can you guys hear when I'm talking to this? Testing 1, 2, 3, 4?
Yes.
Okay, good. All right, go ahead.
having anything to do with the Honorable Justices of the Supreme Judicial Court sitting as the law court at Portland within the state of Maine may come forth and declare it shall be heard.
Good morning. You can be seated. The matter before the court is Penobscot 24-506 regarding children of Miranda. I see counsel are present. We have a new sound system, so we're hoping everything works really well, but we are also being streamed on the web, both by audio and by video. Before we begin the argument, I would ask counsel to identify themselves for the record by saying your name.
Joseph Short, Your Honor.
AAG Hunter Humphrey for DHHS.
Thank you. And Attorney Shigori, if you're ready to proceed, we'd be happy to hear your argument this morning.
Good morning, Chief Justice, Your Honors. May it please the Court, my name is Joseph Shorty, and I represent the appellant mother in this case. Unfortunately, in Maine, there are many cases in which a parent faces a department petition to terminate their parental rights. In virtually every case, the parent has had a constitutionally protected choice: contest the petition while accepting the risks of doing so, or consent to termination. This decision is terrible and important, but it is ultimately the parent's own. My client did not receive that choice. Instead, the AAG, representing the department, told her that, on no uncertain terms, to contest the petition would effectively end her efforts to reunify with another, younger child at a different phase of the child protective proceedings. With this case, this court has the opportunity to right this wrong and allow the mother to exercise her rights, tell her story, and to fight to continue to parent the children she loves.
I see that the green light is on. In this case, the mother left the courthouse before the hearing, correct?
That's correct.
But nonetheless, although it was entered as what could have been a default, it was done without prejudice, in other words, not to be considered involuntary. Is that correct?
That's correct.
So essentially, she got the benefit of a consent after a contested hearing.
I would argue that the hearing was not contested.
Well, it wasn't contested because she wasn't there, in that sense.
That's correct. She was not there, and her attorney believed at the time that she was effectively consenting.
Okay?
But her attorney was there to be in a position to ask questions of the witness that was put on by the department with respect to the issue of termination, correct?
The attorney was there to ask questions, but he believed at the time that that the mother did not want to contest the hearing at that time. But
Well, isn't that belief borne out, even if it hadn't been based on any conversation, borne out by her actions, given that she left?
I think to go back, you have to understand why she left and the upsetting situation that she was in. She was a mother of 3 children who admittedly had tried to decide whether or not to contest this hearing. But her own attorney said, even somewhat to his surprise that morning, she was ready to contest the hearing. They had prepared for the hearing. They had identified witnesses. There were numerous witnesses ready to go. And up until they took a brief recess before her hearing, that was the position she had.
Counsel, there's no question that she was, between the proverbial rock and a hard place. And any parent who's in that situation is faced with a real difficult dilemma. My question is, does it matter how and what the AAG said? And were there specific findings of fact in that regard?
It does matter what the AAG said and how he said it. And the court...
And what did he say? And what's your version, or what do you think the record shows he said and how he said it?
The record shows that he approached the mother outside of a normal settlement conference, just the mother and her attorney, and told her that if you were to go forward with this hearing, you will lose your ability to reunify with your youngest child. And
Well, did he Did he put it that way? I mean, in just looking at the materials here, the motion for relief puts it rather starkly. In other words, he said if you go forward with the hearing, he believes she would lose and the department would never let her see her child again. That's not exactly supported by the affidavits that are attached to the motion. I mean, was what the AAG said true and accurate?
I think there's some question as to whether or not it was accurate. He provided, his telling of the events was that the court could, and this is, remember, you're looking at this from the perspective of educated judges and lawyers, not from the mother's perspective who is hearing these $50 words as he described them.
But she had counsel with her, and she spoke to her counsel after the AAG departed.
She did speak to her counsel for about 15 minutes with multiple interruptions from the court officer, with the hanging sort of specter of this hearing that had to happen, that everyone wanted to get going if that was going to happen.
So are you saying that any litigant in any case, not only protective custody, upon hearing the opposing counsel's opinion on the case and being confident about it and hearing that and getting stressed out and leaving somehow triggers a due process issue?
I think there are a number of factors more than just that simple telling. Obviously, there could be many different scenarios in which an attorney could tell another litigant their opinion on the case, and that litigant leaves, and that would be fine. But in this case, you have to remember, the mother had history with the department, and specifically AAG Downey.
Sure, and she's predisposed to get stressed out, I would think, based upon those experiences. But if what the AAG said was in fact true, if this case goes forward and the TPR is issued, then that will relieve us from an obligation to reconcile and provide contact because it's an aggravating factor. If it's a truthful, accurate statement of the law, and the AG expresses confidence in their position, and she leaves, that triggers a due process violation?
I think there's some argument that whether or not this was truthful, or at least presented in a way that was accurate.
Well, but don't we have to accept what the judge found to be? I mean, the judge's recitation is that during a recess in proceedings, the AAG entered a conference room where the mother and her attorney were waiting to discuss the pending matters with her attorney. The AAG, and I'm quoting, expressed confidence in the department's case for termination and reminded him that a judgment of termination after hearing could become an aggravation factor in the case pending for jeopardy hearing, potentially resulting in a cease reunification order. That's what the judge found happened, right? Aren't we bound by that? Isn't that supported by the facts? One could have perhaps interpreted it differently, but isn't that supported by the evidence?
I think what the judge found was not supported by the evidence, and that's not what either AAG Downey or the mother took that conversation to mean. AAG Downey described his conversation as, the department might want me to make the argument that, telling the mother this, the department might want me to make the argument that if the court grants the TPR and we're trying the jeopardy, I ought to just make an argument for the aggravation factor and cease and cut to the chase.
But isn't that just a different way of, I mean, the judge wasn't saying what Attorney Downey said or what the mother said. He was interpreting what he believed happened, and and that is one interpretation of that is exactly what the judge said, isn't it? That a judgment of termination after hearing could be an aggravating factor and potentially resulting in a cease reunification, which is accurate.
That is accurate, but he's saying, in his own words, that the department was going to take that action that
Why
day.
does that matter?
Well, because the judge, in order to get there, would have to make those findings, if there's determination, unless the judge was going to find from the bench that day an aggravating factor, the mother was not going to lose the reunification efforts with her child on that day. And that is how he presented that being
Well,
a
wasn't
risk.
there a Jeopardy hearing that was also scheduled to be taking place at that same time with respect to that younger child?
The Jeopardy agreement was,
No, I'm talking about a Jeopardy schedule. Wasn't there a Jeopardy hearing scheduled for that same day?
there was, although I believe that the Jeopardy agreement had already been,
Well, that was part of the, well, I don't want to go that far yet. My only point is that when they walked into that room and she was going to contest the TPR, there was still going to be a Jeopardy hearing that day, correct?
yes, there was Jeopardy.
There were further discussions that took place that ultimately resolved the Jeopardy piece, and also there was the resolution of the TPR not having the impact of being an aggravating factor that ultimately got worked out. Is that correct?
Yes.
Well, you suggested there were threats being made by the Assistant Attorney General when he went in. That isn't borne out by the evidence in this case, is it?
I think if you look at how the Assistant Attorney General felt in this case, and the record is full of examples of this. So he was disdainful towards the mother. He felt that the mother did not have a chance to reunify with, that she would lose the hearing that day and did not have a chance to reunify with her younger child. He said,
As you're walking through the facts here, can I just take you back to the Chief's question? The Chief read the court's findings. Is it your argument here today that the record, that the evidence, compels a contrary finding than what the judge actually found here? So that's a bold stroke for us to say to the judge, oh, boy, the evidence here compels a contrary finding to what you did. Is that what you're asking us to do?
well, I think there's an error of law in how the judge, how the judge interpreted how the Assistant Attorney General presented what the
One could have interpreted it differently. There's no question. But the judge interpreted it one way, and I read what it was. And are you suggesting that that is, as a matter of law, that the evidence simply does not support that?
Unraveling what the Assistant Attorney General said was not legally correct, and therefore, when saying this was accurate, factual legal advice, that's not accurate either.
What was inaccurate?
That the reunification was going to cease that day if she were to go forward.
Well, the judge found that he didn't say it would, he said it could, and that's different.
But that is not what the Assistant Attorney General testified to saying.
Can I ask you another question in the seconds that you have left? Part of obviously a claim for ineffective assistance of counsel, or for that matter, I think your due process claim as to whether there was a violation of due process, both involve showing it mattered, that there would have been a different outcome had that conversation not occurred. Is there anything in the record to suggest that that is the case?
Well, may I answer your question?
Yes, you can.
Well, the mother didn't receive the hearing. She never had the opportunity.
But the outcome has to be different.
The question is, how do you know asking the mother to prove that the outcome would be different?
But isn't that one of the elements of proof, is my point, both on a due process violation, i.e. prejudice, as well as an ineffective assistance of counsel claim?
She had witnesses she was ready to present and was not able to present those witnesses. What those witnesses would have said is difficult to determine.
Thank you. The red light is on, but hang on a minute. Colleagues, counsel.
May I have one more?
Yes.
I won't be counsel, I'll just be a colleague.
You're being colleague.
Just as an epilogue to this, as we know, the TPR order issued, but it had some language in it that the involuntary nature of the TPR shall not now or in the future be construed as an aggravating factor under Title 22. So she actually accomplished the result that caused her to make the decision. Does that have any effect on the arguments you're making here today?
No, Your Honor, because she wanted to be able to argue and felt like this was the only option available to her.
All right.
Go ahead.
Two questions. One, isn't it consistent with what's in the record that her attorney, in fact, did discuss the possibility of losing in the context of the TPR, that being an aggravating factor with respect to the younger child?
She discussed that with her counsel prior. Correct?
Prior to coming, okay. And then the second point would just simply be that as a result of what she heard, understanding that she has some mental health issues, is that part of the argument that you're making, that that's why this was a due process violation given their history and given his knowledge of her deficits?
It's a constellation of factors. It's one part of it, yes.
Thank you, counsel. Attorney Humphrey.
May it please the court. The children who are subject to this proceeding have been in state custody since April of 2023, over 3 years ago. The appellant's entire claim hinges on an interaction estimated to have lasted between 30 seconds and 5 minutes. Below, where as the moving party, the appellant bore the burden of proof, she failed to persuade the fact finder that her description of that period of time was accurate. And I think all the parties to this case agree that accuracy is very important. The appellant's star witness, her trial attorney, conceded that it, quote, might be a stretch to suggest that whatever happened in those few minutes impelled the appellant to leave the courthouse before her termination hearing began in August of 2024. If the outcome of this years-long proceeding is truly dependent on a fleeting moment in time, there are others to consider. Immediately after the interaction that the appellant wishes to highlight, she conferred with her attorney privately for 10 to 15 minutes. Immediately after that, she knowingly and voluntarily decided to walk out of the courthouse and onto Exchange Street, even though she knew her termination hearing was about to begin. Immediately after that, her trial attorney told the judge that the appellant had authorized him to proceed in her absence. By definition, that conduct constituted abandonment within the meaning of the statutory framework. Nevertheless, the department and the district court provided her the benefit of the outcome that she had selected, which is what her trial attorney described as, quote, a friendly default, shorn of any aggravating factors. That's a fundamentally fair outcome. I welcome your questions.
Well, let me ask you this. What the heck was the AAG doing going into the conference room and talking to her directly, that if, regardless of how it was phrased, and I'm not saying it's necessarily a violation of bar rules, her attorney was there, but nonetheless expressing that we're going to win and you should consent. What the heck is he doing that?
So at the motion hearing, he testified, former AAG Downey did, and here's a quote of what he said he would not have done. Quote, what I would not have done is I would not have stepped into the province of the mother and counsel of making the sort of solemn, grave decision. I transposed those, grave, solemn decision about whether or not to voluntarily consent. What he described in his testimony was that the thought had occurred to him, that he was not certain that everyone had considered what the potential effect of an involuntary termination aggravating factor here could be on the other pending case.
Which is a very basic thing for any attorney representing a parent in a child protective case to understand. This attorney was a very experienced attorney on there's no reason why, if an AAG has a concern that an attorney hasn't advised his client, wouldn't the conversation be with the attorney, not with the client?
I think, Your Honor, after this court brought the Strickland standard from criminal law to these civil litigation matters, one of the consequences of that has been that counsel for the agency needs to ensure that all parties are apprised of everything that they might need to consider, because it's foreseeable otherwise that someone may move for relief from judgment on the basis.
The AG now is assisting the defense counsel?
I don't think that that's the
And
way I would
talking
describe.
directly to the parent and saying, these are the consequences if you don't do this?
This was an individual who, in his testimony, described that the thought had occurred to him, that people may not have fully considered this. He put it on the table and left. This is an interaction that was described as lasting 30 seconds to 5 minutes. I think, suppose the appellant is correct, that it's some manner of due process violation for an interaction like that to occur. There would be ramifications of that in the way that dispositional conferences occur in courthouses around the state every day. These sort of informal interactions occur, and the safeguard due process-wise, is the ability to go from the conference room into the well and tell the judge what just happened. Attorney Boss was unequivocal that if he thought something wrong had occurred, he would have told Attorney Downey, he would have told Judge Roberts.
And that's why I prefaced it by saying, I'm not saying it was actually a violation. I mean, I understand Attorney Voss was there, all of that. It just seems like this shouldn't even have been an issue.
There are multiple aspects of this case that seem like that. There's a delta that is significant and troubling between the statements that Attorney Boss made on the record to Judge Roberts that day, the statements he made in the affidavit that the appellant procured months later, and the statements he made in his testimony at the motion hearing. Very hard to understand the journey that we went on from point A to B to C in that regard.
If the AG really is taking affirmative effort to prevent the parents' counsel from making egregious errors that may result in an IAC proceeding later on, would the best practice be to have these conferences just with the attorney, or to have them on the here? What we're talking, the chief read the court's findings, and then they were a distillation of what the court heard during the hearing. And each attorney apparently had a somewhat different spin on what took place during that session. Would the better practice be to either record it or simply have conversations between the attorneys without involving the clients, so there won't be the risk of the client being scared by the Attorney General?
I think certainly after this, I would say that would be prudent. We're talking about attorneys who had worked with one another for decades, and I think there was a level of trust and collegiality that had developed, and that informed the decision to have this conversation in these few minutes that occurred. We're also operating in a fact pattern where, at the motion hearing, Attorney Boss explained that when the mother made the decision she made to leave the courthouse, she made it after having watched the parent of one of the other children make this same decision.
But the Rule 60 motion was couched in some pretty extreme language, misconduct of an opposing party. That's some strong stuff to put in a motion before the court. So the result here was the fact of this interaction, which perhaps was innocent, well-intentioned, now is being recast as misconduct. Your response?
It's troubling. That's why we agreed to go back. This motion was filed on the eve of the due date of the brief in the termination appeal. The extreme allegations were such that we agreed to go back and have a factual record developed at the motion hearing stage so that the court could get to the bottom of what exactly happened. And it was through that process that the allegations fell apart as unsupported. Applying the standard of review, there's no evidence in the record that would have compelled Judge Roberts as the fact finder to find that the mother's account of what happened was accurate. The factual findings Judge Roberts did make were amply supported by the record evidence adduced at trial. Thank you.
Thank you. Attorney Shigure, you reserve 3 minutes for rebuttal.
When I was last up here, I referenced a constellation of factors that led the mother to be threatened by what Assistant Attorney General Downey said. So putting yourselves in her shoes, imagine being in this highly charged state of being ready to go to a hearing for the right to parent your 3 children.
So here's the thing. I can understand what you're saying. I do. And that her interpretation of what an AAG, oftentimes a parent and a child protective, certainly views the department and the department's attorney as their enemy, and viewing it all through a different lens than perhaps it was intended. But I'm still left with the question of, so what? What difference does it make? And how isn't it your burden to show to at least raise a question that it would have made a difference. And so, although the judge below frankly didn't get there because of his findings, I mean, that's a requirement both on a due process violation on the straight appeal as well as on an ineffective assistance of counsel claim.
So I think the case most on point for that is Kenneth S., where there was this due process violation found, but the court effectively, using your language, said, so what? But the issue there was the father had received 4 days of hearings. The court had the information in front of it to make this decision. If you effectively robbed the mother...
I can understand that we may not have all the information to be able to judge for ourselves how much information would have favored the mother or not. But isn't it your burden to give it to us, is my point.
That would put a parent in a catch-22 where if they don't have a hearing, how can they show that the outcome of this non-existent
Isn't
hearing...
that part of the purpose of the affidavit submitted in support of the 60B and for having a 60B hearing, is to say, and by the way, here's all this wonderful evidence that would have shown she's a fit parent?
But without, again, there's
An offer of proof, in other words.
Something.
the 60B motion was, in this case, was designed to put on the record the inappropriate behavior by the AAG.
Wasn't the
Understood.
purpose of the 60B hearing to demonstrate how she was deprived of her due process rights by what the AAG did? And isn't that what we're saying there's not a demonstration of?
But Your Honor, the mother has a fundamental right for an opportunity to this hearing. To say she didn't receive that hearing and we don't know what her witnesses were not able to testify, to then try to go back and recreate that when the option is to give her that hearing and allow her to tell her story. The damage
Which, if
done-
it's futile, in other words, if it's clear that the evidence would have resulted in a termination in any event, why should we?
It would put an extreme burden on parents to effectively present their whole case in an affidavit for the court just to potentially then receive that hearing.
Thank you, counsel.
Thank you.
As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. Attorney Shiguri, I understand this is your first trip back to the law course since you were a law clerk, at least in person.
That's correct.
And as is also our practice, we invite counsel to come back and take the greetings of the court. I see you have some colleagues here, so if they wish to come, that would be fine too. Good morning. You can be seated. The matter before the court is Andrew Scoggin, 25-364, State of Maine versus Duane Hanson. I see counsel are present. I'm assuming you're ready to proceed. We have a new sound system, which it seems like it's louder, but anyway, we are also being streamed on the web, both by audio and by video. Before we begin the argument, I would ask counsel to introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning, Rory McNamara for the appellant, Duane Hanson.
Good morning, Catherine Hudson-McCrae, Assistant Attorney General for the state.
Thank you. Attorney McNamara, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Thank you. May it please the court, Attorney Hudson-McCrae. Our case is easily resolvable by the rules of evidence. That's not really what tripped up the trial court. With all respect, it was this court's judge-made alternative suspect test. So I'll begin this morning by making another pitch.
Let me ask you this, assuming it should have been admitted for impeachment purposes at a minimum, the statements that the victim allegedly made to family members, should it also have been admitted substantively?
Yes, it should, Your Honor, if that's a yes or no question. But I don't think there's much of a doubt that it was admissible substantively. And we didn't really reach, I was not trial counsel, the defense did not really reach the issue of the hearsay analysis. It was essentially denied at that step according to alternative suspect test. But I think there is one, as a matter of law, that would be applicable without doubt here, and that's 801D1C, if I've got the numbers right, a statement by an individual who is produced as a witness, subject to cross-examination about an identification of someone perceived earlier. I think there's case law that I've cited, as well as some treatises that says it doesn't matter that the declarant testifies and denies making that statement. It can still come in substantively.
Well, can I ask you about that, counsel? So this seems a little different than sort of a statement of identification. I mean, I think of a statement of identification as the witness identifying a person that perpetrated the crime. And in this case, the evidence was really about a completely different situation, right? I mean, on the one hand, there was an issue about whether her partner at the time assaulted her, but what she described was a completely different episode, which is maybe two women and a man jumped her in Lewiston or Auburn. So how does that fit within that hearsay exception?
Your Honor started with the premise that the exception is normally about someone who witnessed a crime, and that is very much the case here. No better witness than the complainant in a case who knows exactly who committed the crime. I would offer that this is the quintessential case of identification of an individual. I take your Honor's point to be one about typically 801DC is invoked in situations where there's a photo array, some out-of-court identification akin to a show-up or a lineup or something like that. I've cited in the blue brief cases where these identifications have been something as simple as going to a victim's hospital bed and saying it was Roger that did it, for hypothetical example. So I think it squarely falls in that. And of course, the rules are interpreted broadly, certainly when there's a constitutional right or a penumbra of constitutional rights as here. And the language, certainly, of 801DC is capacious. It doesn't restrict itself in any manner to line up.
Counsel, does it require a specific identification? In other words, what if the statement was, I was mugged in a back alley by 3 people and I don't know who they are? Would that be admitted substantively?
Well, a general statement like that, I do think it would be. Certainly to the extent that would exculpate a defendant is very relevant. To the extent it's something along the lines of it was 3 people other than the defendant. But what we have here is also a little bit beyond that. We have additional identification. We have the fact that there were 2 females on a drug dealer named Casper who hit with a shovel. So I think there are more details than in Your Honor's hypothetical.
Can I go to the evidence of the prior assaults that was admitted
Yes.
from
Yep.
June,
Right.
the assaults from June? There was a specific unanimity instruction in this case, correct?
Correct.
Somebody paid attention to what we've been saying. At the time when it came to be admitted, the state seemed to be arguing both that it would be admitted to show, absence of mistake, motive, opportunity, all the things that we say other than a prior, but also that it be admitted as the basis of conviction because one of the counts alleged to have occurred, I think, in August, and that's close enough to be
Right.
on or about. I was very unclear whether the defense was sort of surprised by the substantive argument. And there seemed to be in some of the transcripts some suggestion that there had been no discovery of that given about any former assault so that it could be the basis of the substantive. Can you shed some light on that?
As I was in trial counsel, I won't make independent representations about what was or wasn't part of discovery other than what was in the record. And I believe the state represented, and I believe defense counsel may have acquiesced to some extent with that representation, that was produced in discovery about those information. To what extent? I don't know. I think part of the surprise about that, though, when we have the dual use that the state had two separate theories, is that we have a lot of litigation, ironically, in this case, about what is extrinsic and what is collateral. When you have a 404B evidence that's coming in about a gazillion prior assaults.
Well, we've certainly historically let in evidence or not of prior assaults in domestic violence cases. That is not unusual. There are other cases where that has come in. So why? Are you, I guess I want to understand the argument. Are you saying it simply is it's really a 403B? In other words, that it really, to the extent there was any probative value, that it wasn't for acting in conformity, it was outweighed by the unfair prejudice? I'm not really sure I understand the argument.
There are multiple pieces here, so I understand the confusion. When discovery happens of an incident, I think the defense counsel has to make a decision. How is the state going to use this? And certainly 404B, to the extent all of these were made discoverable, is a possible theory. I absolutely agree with that. But it is quite a jump to go to substantive evidence as on or
But
about.
with a specific unanimity, if, and there's certainly on the record is at least not a clear violation of not having notice of that.
Well, I want,
from discovery. And if they're combined with that, there is a specific unanimity instruction, how is there prejudice?
well, we're talking about lack of notice, which is one component of the duplicity or the material variance analysis.
Yeah, but we won't know if it's a material variance.
Right, but I'm just saying lack of notice is one component, and that's what I'm referring to, and I take it Your Honor is referring to right now. And in that, defense counsel, I don't think, can presume that this is evidence that they need to go out and find witnesses to come in and rebut about a collateral matter with extrinsic evidence to do that. And that's the difference in preparation. When you know something is coming in substantively, you should absolutely do that. And their representations on the record, and I think fairly so, that wasn't indicted. So to take a step back, that's lack of notice. And specific unanimity is another silo within the analysis of material variance and or duplicity. Another one is the grand jury right, and that one's the easy one to mention. What are the chances, A, that
Well,
the
we
grand
don't
jury-
know, is my point on the grand jury.
Well, that's a serious problem, with all due respect to this
Well, I'm not
court's
sure it's so
Rule
serious
6.
given the historical secrecy of grand jury.
Counsel, is there any really reasonable basis to believe that, I understand that the judge let it in without, I guess, as substantive, but it was never argued as substantive evidence. I mean, what it looks to me is like maybe it was really used by the state as 404B. There was just no limiting instruction in the sense that the state's closing argument is keyed to the dates in the indictment. The jury verdict form is keyed to the dates in the indictment. Tell me if I'm wrong, please, but I don't see anywhere that the state or the judge's instructions or the jury verdict form refers back to anything that happened in June. So isn't the real problem here just that it was 404B and that there wasn't a limiting instruction? Isn't that sort of what we should consider as to any prejudice?
I'm not finding it right now in the briefs, but at one point, either the blue or the gray, I'm sorry, I've cited where
At
in the
one point, I'm
states.
sorry, I didn't hear what you said.
I'm sorry, at one point in the blue or the gray briefs, I'm not finding it right now, I will look when I sit down. I catalog where the state in closing argument very much harped on, for lack of a better term, these incidents, including beginning its closing with what happened at the beginning of the summer. And
Right, I saw that, but I guess still in arguing to the jury, here's what you have to find, it looks to me like it's all keyed to the dates in the indictment.
I think there was an honor about instruction from the court, which leaves it up to the jury to decide what we believe. And there were certainly differences in the defense. We had in the latter indictment occurring at the end of October, a defense, an alibi defense, in fact. So there was a possibility the jurors would say, I believe this alibi defense, or at least I have reasonable doubts based off that defense. I'm going to go to this stuff in June. The court's instruction didn't say anything about it. There was no election. I read last night very closely the state's closing and rebuttal closing. There's no election that's saying this is the date that it happened. This is the incident that we're talking about. And this court's case law, Your Honor's decision in Paquin in 2020, says when it comes to a double jeopardy violation, so the same statute, multiple incidents, which is very akin to what we're talking about here, and in fact, one of the parts of the analysis of the variance, we're not going to assume that jurors picked one rather than the other. We're going to take from that the possibility that they chose, something that wasn't charged. And I think
Which means he cannot now be he could not be prosecuted now for a June assault because we assume that.
Right, and that goes to part of this variance problem is that Mr. Hanson was acquitted of some things. Mr. Hanson may have been acquitted had the jury been required to find on X date, X incident, what happened. But we don't know. And that's what the case law and the treatises say. The material variances create this kind of problem. And it's one that regularly recurs in Maine, unfortunately. Here we have, I think, unique circumstances of acquittals in addition to those.
Well, the acquittal, weren't those weapons charges that he was acquitted on? Did I get that wrong?
One of them involved that. I have in front of me, there were others.
Counsel, I think they were both ones involving allegations of machetes, and then there was the kidnapping.
Well, so count 5 in that Androscoggin indictment around 1029. Oh, I see the red light is on.
Finish your sentence.
Alleged a very elastic term called extreme indifference in addition to the weapon. So extreme indifference is in the eye of the beholder. Jurors could have based their conviction on.
You don't go anywhere yet. I'm going to turn to my colleagues and see if anybody has any additional questions despite the red light.
Can I just go back briefly to the prior inconsistent statement issue there? If the court was correct that the defense didn't establish a reasonable connection between the alternative suspect and the crime and was not admissible, but continued to offer it as a prior inconsistent statement, wouldn't Rule 403 knock that out there, because the jury hearing that is going to hear all about the alternative suspect and treat it as substantive evidence, even though it's not being admitted as such, and because that danger exists, then the whole thing should be excluded?
I think even in that case, the Constitution, the due process, confrontation, those rights are implicated. And I think it would have been an abuse of discretion if 403 had been the basis to keep it out alone. And I also don't think it's reasonable to say that there's no reasonable connection to a confession In other words, it's a confession. It's akin to a confession. We talk about corpus delicti law. We talk about cases of DV prosecutions where an alleged victim has recanted. We would never think of saying that that's too attenuated. That's not a reasonable connection in cases. And the same should cut for defense. Our defendant here. Thank you.
Go ahead.
Counsel, could you just, it wasn't clear to me from the record, the three family members, or maybe it was four family members who were going to testify about what they heard the victim tell them. So the jury convicted the defendant of assaults on 3 separate occasions. Were the witnesses going to testify that she reported being jumped by these people on one particular occasion? Or can you just sort of describe a little bit better what these witnesses would have said?
There's ambiguity, and I can't go outside the record, obviously, about when that occurred. My understanding is that was primarily geared towards the later portion of October. There is other information in the record, though, that some of these statements about being jumped by other people, including 2 women, occurred as early as June. And that's all I know based off of what...
But was it just one incident that they were going to describe? Were they just going to testify that there was one episode where she was jumped by these people?
I think that's a bit of the problem. We didn't have a voir dire of the 3 witnesses. We simply had a voir dire of the complainant to get into, well, did you say this or not? And then based off of trial court's determination that no, she didn't say this, it was excluded right there. Thank you.
Any other questions, counsel? Or counsel, I'm going to do it.
Yes, I have a few, if you'll permit me. Sort of piggybacking on what Justice Taub was just asking you, let's assume for purposes of argument that we think it was error to not have allowed the 3 Hanson family members to testify about what the victim told them, just for impeachment purposes. So I'm not talking about substantively, but just to challenge her credibility. What is your view? I mean, I know your view, but I want to hear why, as to why the exclusion of that testimony wouldn't be harmless, given that other information was introduced in front of the jury, that she had lied to people about who assaulted her, that she had told different stories. In addition, there was corroboration, for example, of the August assault by the 911 caller. So when you sort of piece together all of the evidence, what is the argument that this still would need to be vacated because of exclusion of those 3 witnesses' testimony for impeachment purposes?
Right at the beginning, there's a header that says, I don't think it's as simple as saying under the rules of evidence there was an error. You'd also have to do in that case to determine which harmlessness analysis applies.
Well, that was my second question. Is this the constitutional or non-constitutional?
And it's a bit odd in that sense, where if there's error, you might still have to go on to the constitutional analysis. But in terms of the substance, the meat of your question, I think it's important, and I don't recall there being statements in the record about lying from the complainant. I remember there being statements and evidence about her not wanting to say, and in fact there was, I believe, like a 9 or 10 month delay in her saying.
Right, but she also testified that she, quote, had hidden and lied to multiple people about what happened. So that did come out, and then her daughter testified that her mom told her she was getting in fights with women at the park. So there, this information was in front of the jury.
Right, and I think it comes down to what were the nature of those lies? Were they somebody else did it, or were they my client did it but minimizing in some manner, or when they were done? We have, again, an alibi defense that is part of the component here. And we have other aspects that are not direct witness saying, I heard lies, or I heard, I'm sorry, not lies, but I heard statements about who caused these coming from the complainant's mouth that is different than maybe kind of a self-exonerating statement that says, yeah, I fudged a little bit. But to hear another witness in the room saying, I really thought, she was crying when she said these things, there was nothing about that made it seem like she was lying. To have witness after witness come in, I think it really trumps the minimal nature of the evidence in there. And there's also, as I referred to, some ambiguity in that, what you just cited about when that occurred. If it was early in June, which was uncharged conduct, or maybe it wasn't
Well,
uncharged conduct.
but which way does the ambiguity cut? I mean, isn't that really a failure of offer of proof by Mr. Hanson about what the evidence would have been? I mean, we have to just go with what was provided.
Well, I think that the nature of the process was here, we would like to adduce that evidence. And trial court issued a decision that says, well, we're going to have the complainant come up and say what it was, and kind of went off of counsel's representations about what that evidence was. But also, maybe the biggest component is that trial counsel wasn't able to argue in closing that Gail was fabricating who did this. There was a kind of a very minimal statement about one sentence or two sentences long that the transcriptionist didn't really comprehend. I think it was meant to come out about what happened. But just going to this issue of credibility, that alone is big for trial counsel to be able to come up and say, well, look, it's not just that Gail said she minimized or fudged a little bit. We have 3 witnesses who actually heard this and came into court and swore an oath and testified in front of you that this is what she said. And for trial counsel to be able to harp on that, again, for lack of a better term, in closing, something that really drives home that point when the Maine courts always or really kind of strongly have language and instructions about look for a motive to fabricate, look for fabrications, consider credibility and inconsistencies. I don't think we can assume away those inconsistencies when they are there.
Colleagues, any other questions? Thank you, counsel.
Thank you.
Attorney Hudson McRae.
Chief Justice, Associate Justices, and may it please the court, I've taken 1 minute of uninterrupted time. I just want to take a moment to answer some of the court's questions that I think might be helpful. As to the Chief Justice's question about whether trial counsel, defense counsel was provided with discovery about the statements the victim made about the assaults beginning in June or July, my review of the record was that in the August 2024 interview between the victim and law enforcement, which was the only time she was interviewed in this case, she did disclose, as part of that audio recording, discussion about how the assaults began towards the end of June, beginning of July. The difference was that my recollection, and I want to be careful about this, I don't believe she used the date June 28th, which is I think what she may have used in her trial testimony, but that was provided in discovery in the August of 2024 investigation. The defendant was acquitted of the dangerous weapon charges as well as a kidnapping. There was a jury note that came in, and although it's not in the transcript, unfortunately, it should be in the court's file. The jury did issue a note asking whether they needed to specifically find that a machete was used as part of a dangerous weapon or whether it could have been any dangerous weapon. The instruction was given by the court. My recollection was that it had to be a machete because that was specifically alleged in the indictment. That was agreed to by all parties, and then the jury subsequently acquitted, of course.
I see that the green light is on, so
Yes, Your Honor.
you may not have gotten to the points you were going to try to make. But can I ask you this? What was the purpose of putting in the assault from June? What are you trying to prove by that, and what were you using it for?
The purpose was for the permissive non-404B reasons, which was identity, relationship.
Okay, well, let's stop you there. There's no question she knows who he is. So we don't need identity. I mean, she knows who he is. Relationship, they've been living together. That's well established. There was no contest as to whether they were domestic partners. What's the next?
The nature of the injuries subsequent to the June assaults dates, I think also articulate who in fact assaulted her. I think the nature of their relationship about what happened.
The nature of the injuries after that. How does putting in the June assault dates articulate the nature of the injuries?
Because of the nature of the assaults. She described, my recollection from her trial testimony is that the strangulations didn't start until later in their relationship, but he started pretty early on giving her black eyes. I think her testimony...
So he did it once, he must have done it again?
No, the
Gee, isn't that 404B what you can't use it for?
It was the nature of the injuries that she sustained was that she testified she had repeated black eyes from the course of their relationship. So by the time the August 21st body cam footage was introduced, where the jury specifically saw her presentation, which included the 2 black eyes,
I saw the video.
that nature of those injuries prove identity of the perpetrator. Even though the defendant was present in that August body cam footage, he was not present for the June interview because the June interview didn't occur. She wasn't interviewed until nearly a year later.
But
after
how
that
does it
relationship.
prove identity other than he did it this time, he must have done it that time? Isn't that exactly what?
You're saying it's
404
modus operandi?
Yes, thank you, Your Honor. Yes, that is what I'm saying, just not as, perhaps, as well articulated by Your Honor. But it was not offered for propensity, and I requested a specific union admitting instruction specifically, not just because of the June assaults, because it was really not offered for that. It was really because of the multiplicity of the charges that the jury had to
No, I
consider.
appreciate that there was a specific unanimity. Like I say, we've been sort of saying, really, when you've got a lot of these, you should be doing that. There's no harm in it.
And then as far as the issue about impeachment versus substantive, Derek Hanson testified specifically, and it came in as substantive evidence, that Casper assaulted Gail in June with a shovel, and that there was maybe blood or hair on it.
The challenge there, counsel, is I don't think that he said, Gail told me, Casper. So he sort of blurts out somebody else did it, but this jury still didn't have before it that the victim had used had told a different story.
Yes, the defense was able to impeach her on that specific point, although my recollection of what actually occurred before the jury is they didn't ask the victim about Casper at all. They just asked her in front of the jury about
Well, because you'd done a voir dire that said she was going to deny saying that anyway, so why ask her?
Well, they would still be able to impeach her. That was a strategic choice that the defense was not able to, that the defense chose not to make in front of the jury.
Well, isn't the impeachment that today she's in court saying it was Duane, Hanson, and on at least 3 prior occasions, she has said it was someone else who caused her injuries.
I think
that's the impeachment.
But I think this case comes down to what the central issue was, which is who did this. This isn't a causation issue, as the defense argued before the court at the trial, and in some instances in the brief.
I'm not sure I follow that argument at all.
And I think that's the important distinction, is that this isn't a case about how she sustained her injuries, whether she fell down a flight of stairs, fell and slipped on some ice.
Of course it is. It's a question of who beat her up.
Yes, and that is why I do not think it is impeachment testimony, that this is really about substantive evidence. This is about who did this to her. And so for them to try to cabin it as impeachment evidence instead of substantive.
Great, so you're admitting it would have come in substantively. I'm still struggling to understand why, if you have a victim of an assault, domestic, otherwise doesn't matter. If you have a victim who today in court is saying this is the guy who did it, but and I understand you don't believe this to be true, but that on 3 prior occasions has told other people that that's not who did it, that someone else did it, how can that not be relevant and admissible?
Because it fails 401 and 403. We also don't know specifically that she said it on 3 separate occasions. They were going to call the father, the grandmother, and the brother to say that she said this to them.
Well, now I understand you were quibbling about, and how credible the evidence is and everything else. But my point is, I don't understand the argument about how that would not be relevant to have when you have a victim of any crime, to ask them the question that or to show that on 3 prior occasions through other witnesses that they've said it happened some other way.
It is relevant under 401. I think it fails under 403, which is 403 and the second
How is it
step.
unfair prejudice?
Because it fails the 403 analysis under the alternative suspect prong. When the court looks at Daly, the court looks at Reese, it is still hearsay evidence. It is still an out-of-court statement that I think really is being offered for the truth of the matter asserted.
How does this even get into alternative suspect? This is a victim saying on one occasion, Tommy beat me up, on another occasion that it was Casper that beat me up. Whatever it is, how does that have to do with alternative suspects?
Because it's who assaulted her. And defense points out in their reply brief on page 10, footnote 2, that there may even be some question as to whether the veracity was believed by defense counsel about this alternative suspect evidence. And I think it is central to this case about who did it. And so if they want to impeach her and say, Tommy, the victim told us at some point, Tommy assaulted her, what they want to stand up and then argue to the jury, as they did to some extent, is exactly that. And that's why they changed their position on alternative suspect at the closing argument chambers conference because they wanted to.
Can you help me understand the court's finding? The court said that the incident involving Casper and the shovel and all that did not establish a reasonable connection between the alternative suspects and the crime. She has injuries, and that they were inflicted upon her in a violation of the law, a crime. And she is allegedly saying at some point they did this. How does that not establish a connection between the crime and charged here and what she's saying happened?
My recollection of the case law, specifically looking at State versus Daly, is that there have been a host of factors this court has sort of looked at about whether or not the proffered evidence for alternative suspect meets this threshold reliability and would otherwise be non-cumulative or unfairly prejudicial. And that includes forensic evidence, that includes prior confessions, that includes, I think
But that's when there's no direct. I mean, in this case, you have direct evidence. You can choose not to believe it, but you have direct evidence. The victim says someone else did it.
How is that not connected with the crime?
The victim only said, if you take, well, the victim actually testified that Duane Hanson was only
I know she denies it now, but I'm saying there are witnesses who would say on other occasions she said someone else did it. And what we said in Daly is there just needs to be a reasonable connection between that someone else and the crime. And how is that not established by her own statements, if believed?
I think part of the issue in the offer of proof by the defense is that there was no reasonable connection between the statement she made and the time of the actual assaults that occurred. The statement she made to the daughter's testimony about the injuries she sustained by two girls who jumped her in the park in Lewiston, I think pertained, my recollection, and I could be mistaken, was that it pertained to the June-July incident. But by the time we get to August and the October incidents that occurred, there's an insufficient offer of proof about when specifically the victim said to them that two women and a guy jumped her in Lewiston over drugs and or that Casper assaulted her with a shovel at some point.
Well, let me ask you this.
So you think that question about the temporal connection between the statements and the crime itself is what the judge based the decision on?
I'm just
trying to understand the rationale for the judge's finding there.
Yes, my recollection in review of the transcripts was that she found that it was not sufficiently connected and that the speculative nature of the names of the people or identities of these alternative suspects was too speculative or too remote to meet that reasonable connection language that the court has articulated in Daly.
So remote in time and no names.
I think it was primarily the names, if I'm remembering correctly, but I do think the time component is an important consideration for this court.
Does the time component matter if, in fact, you're putting in evidence that basically from the beginning of this relationship in June that he's beating her up? I mean, that she's saying he's assaulted me many times. Doesn't it matter? It doesn't matter which of those occasions, does it? That she's saying someone else was the one who assaulted her?
I think the time does matter, and I think the defense offers of proof in this case were wholly inadequate to be able to answer some of these court's questions. And if this court does find that it was prejudicial, I still think the exclusion of this evidence, again, for impeachment purposes, which is primarily the basis that it was excluded or was argued for the admission by defense, was harmless error. Because for this court to say that that actually rose to the level of such prejudice, either constitutionally or under an abuse of discretion clear error standard, I think the court logically would have to find that this evidence really should have come in substantively, not for impeachment purposes.
Is the analysis here warped by the alternative suspect framework? In other words, if she was assaulted anonymously in a back alley in Lewiston by 3 people and then told several people subsequently that that's what happened, wouldn't that be admissible?
I think the distinction in my mind between that hypothetical and this case is that the defense was trying to offer identities of those other people. And that, I think, is a distinction. They're trying to suggest that it is 2 girls and a guy who jumped her over drugs, or this elusive Casper with a shovel at some point, maybe in June.
See, that brings me to, you seem to be suggesting, and you seem to suggest this in your brief, that our alternative suspect jurisprudence somehow makes evidence less likely to come in than it would be otherwise, and that it's sort of trumping other rules, the just general rules of when you could cross-examine somebody for a prior inconsistent statement.
I apologize, I do not mean to suggest that, because what I should have, I think, clearly articulated in my brief, perhaps more so, is that the alternative suspect analysis is just application of rules 401, 402, and 403. It is not, as the defense, I think, tries to suggest, this warped view of avoiding some constitutionally permissive evidence that should otherwise come in. It is just an application of 401, 402, and 403. But in order, I think, to meet the standard, in other words, in order to be permissive evidence under those rules of evidence, there has to be a reasonable connection between the people, these alternative suspects, and the crime that was committed.
And it's your position there is no reasonable connection if somebody says the victim said it was this other person?
Well, I think it fails one, because step one is it has to be admissible. I think that's hearsay. Because it's really coming in to say, this
Why
other
is that
person
not
did it.
801 statement of identification under 801D1C?
Because I don't think it's someone she perceived earlier. She's fully denied.
Well, that's because you don't believe that it happened.
But it's, they didn't see anything happening. And I really do not think it's under, I don't remember the rules specifically. But
That's okay. Statement of identification, 801D1C.
Thank you, Your Honor. I don't think it meets that standard because it's not someone she perceived earlier.
Can I ask, counsel, putting aside whether it should have been admitted for impeachment, just on the question of whether it should have been admitted substantively, what's your view on whether the defense waived that? I understand once the evidence was closed and before closing argument, they said we want to preserve it, but several times throughout the evidentiary portion of the trial, they said, we are not presenting alternative suspect evidence. This is only for impeachment. I mean, why? And I don't think you argued waiver in your brief, but why isn't it waived?
I didn't argue waiver specifically in the brief. I do think it's waived because their responsive motion in limine specifically said we do not have a basis to argue alternative suspect. We only want this in for impeachment, which is why I think they only could argue for impeachment and not substantively. We get to the voir dire of the victim, and it's still, again, just for impeachment. We get to their testimony seeking to introduce it through the father and the brother and the grandmother, and it's the same argument. It does come in substantively from my perspective with Erik Hanson, and then we get to closing. And I think by the time the evidence is closed, they've lost any argument that they could make that this evidence should have been considered substantively, because the trial court then didn't have the opportunity to make those rulings as the evidence was sought to have been admitted itself. I know opposing counsel in the reply brief argues now that it also should have been considered substantively, but again, that evidence would have to have been admissible. And for the Hanson family members to testify that the victim said she was assaulted by Casper or two women and a guy is hearsay. That is hearsay evidence.
Other questions from my colleagues? Go ahead.
Question. If it was admitted or should have been admitted for impeachment purposes only, what record facts do you point to argue that it was harmless error?
Yes, Your Honor. The victim testified that she had been using drugs with the defendant, that she had been, that they had bought drugs together, that the daughter testified that the victim had told her that she had been assaulted by two women in the park. We also have the testimony from the defense medical expert, who also, I think, raised some questions about the believability about the victim's statements after reviewing her medical records and the nature of her injuries, specifically around the use of a dangerous weapon, as well as the significant scar that runs the center of her face. I think that challenged the victim's credibility. Erik Hanson testified substantively that we should be asking Casper about what happened. I think he also testified about the two women and a guy, or at least two women version of it as well. And then, of course, I think they were able to argue, I know opposing counsel believes it was too limited, but they were able to argue that is it easier to say that Duane Hanson did this than to say that a more violent drug dealer, and I'm paraphrasing, excuse me, but a more violent drug dealer assaulted her.
In considering the issue of harmlessness, in your view, does the victim's testimony all rise and fall together, or could we look at each incident separately? So, for example, the August incident, one could say has more corroboration because the neighbor testified, I hear, Mr. Hanson beating his girlfriend, as opposed to the late October incident, which really is just based on the victim's testimony. Is that appropriate in considering whether exclusion of this evidence was harmless?
Absolutely. I do think it all works together because, again, as Your Honor articulated, this modus operandi about the nature of the injuries as the state argued in closing, but the strength of the August incident, especially where you see the defendant coming out of the room and officers walking in moments later with those injuries, and then and the 911 call specifically as well, I do think the court can parse those out for a harmless error analysis, yes. But of course, I don't want to concede that I don't believe that there is harmless error.
Thank you.
Counsel, can I just ask you about the sentencing issue? So I think the defendant is arguing that that the sentencing court sort of failed at the first step of the Huey analysis because the court, in looking at the seriousness and nature of the offense, it looked at injuries that didn't meet the elements of the lead charge. So it was looking at injuries that, according to the defense, weren't serious permanent disfigurement or loss or substantial impairment of the function of a bodily member or organ. I think that's what the defense is arguing. I'm just wondering, is it appropriate in that circumstance for the court to be looking at other injuries that may not meet the elements of the lead charge?
If it pertains to that specific offense and the specific assault that occurred at the time that that offense was committed, yes, I think it's appropriate. In the way in which that offense was committed, it also included a strangulation event as well and some of the other injuries, even though the specific elements were pertaining to the serious permanent disfigurement.
Thank you.
Thank you.
I've got a number of points about waiver. The point of Rule 51 is to put the court on notice so it can make a ruling. It and the prosecutor repeatedly said, we knew all along that this was being offered substantively. The court said, I consider that my ruling preserved, and you can take that to the law
I understand that, counsel, but just looking from the trial court's perspective, you're asking us to say that although the defense attorney said, I'm not offering it for this purpose, the trial court should have said, actually, it is admissible, and I'm going to admit it for that purpose. I mean, doesn't that go against sort of the party presentation principle?
Inartfully, with all due apologies to trial counsel, he said that. But that was the first step of the analysis. It stumbled at the alternative suspect test, and that's where the court excluded it. Is there a reasonable connection? And counsel was saying, okay, I'll back up from that. I'm offering it only for impeachment purposes. And that's why it's the same reason there was never a hearsay analysis. The court simply never got to it. But yet everybody knew that that was the reason. And the prosecutor argued that's why it shouldn't come in, because they're just going to turn around and use it substantively. As for this information about Derek, what he blurted out on the stand, the implication, page 10, note 2 of the gray brief, is that by asking no follow-up questions about that blurt out on the stand, because trial counsel was prohibited from doing so, it signals to the jurors, yeah, I don't believe that. It's a bunch of nonsense. And the fact that it wasn't argued in closing, again, underscores I don't
well, and
believe
that statement was not that clear anyway.
Well, that's true. And again, that's not the complainant's statements. Backing up for a second to get to this variance issue, there is a significant paradox between saying on one hand, yeah, those are on and enough about to be admitted so the jury can consider them and base their verdicts on them, but then to get to the law court and say, well, we know that the jury didn't base their verdicts. I'm laughing as I say it because it's laughable to say that it's reasonable on one hand but not reasonable on the other. If anything, because of the constitutional rights, alternative suspect evidence should be introduced more readily than anything else to preserve a right.
Well, I thought your position was that the whole alternative suspect analysis need not really be imported. This is a much more straightforward. This is, we have a victim saying on other occasions to other people that someone else is responsible for the crime.
I think counsel could have, and there's a gray line that's blurred, I understand. Counsel should have been able to argue, well, Gail said this was done by Casper and 2 women, so to the extent that falls in alternative suspect evidence, we should not have increased scrutiny. And we know that that's what happened in this case because that's what Justice Archer said. Justice Archer said, I'm not letting it in under that giant line of case law over there that says, so application of the rules of evidence 403 is simple enough. Judges do it all the time. They can do it here. And this is fundamentally sound evidence that goes right to the core of the matter. Thank you.
Thank you, counsel. Thank you for the argument here this morning. And as is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
seated. My apologies for the delay, counsel. The matter before the court is York 25-189, State of Maine versus Erik Valeriani. I see counsel are present. We are being streamed on the web, both by audio and by video. Before we begin the argument, I would ask counsel to please identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning. Rezvana Genji on behalf of the appellant.
Good morning. Madelon Thomas, Assistant District Attorney for the State of Maine, appellee.
Thank you. And Attorney Ganji, we are happy to hear your argument here this morning.
Good morning. Chief Justice Stanfield, members of the court. In October 2024, a jury found my client guilty of 2 of the 5 counts of the indictment. First, count 2, domestic violence aggravated assault, and then count 5, domestic violence assault. The former was based upon an 8 to 10 second strangulation incident. On the latter, as the sentencing judge said, quote, "We don't know exactly which incident the jury found the assault on," unquote. At trial, the state presented evidence of at least 3 different instances of the offense, all allegedly committed against the same complainant. The indictment did not specify any additional facts underlying any of the charges. In addition, there was only 1 alleged victim. Lastly, Mr. Valeriani was charged with and convicted of only 1 count of domestic violence assault, meaning that the jury had to agree unanimously that at least one of the above 3 alleged incidents that could qualify as domestic violence assault occurred. Under the state constitution, in indictments and convictions alike, unanimity is indispensable. As such, the court should have given specific unanimity instruction. This court's case laws support the same. Neither party requested the instruction, nor was there an objection to the trial court's jury instructions. This, as such, was plain error under both the state constitution and this court's case law. And the error violated my client's constitutional rights to unanimity in verdicts. Second, the sentencing court acted illegally as a fact finder by finding aggravating factors based upon facts which the jury had already rejected in what they had found my client not guilty of. Aggravating factors must have a basis in fact and law. Otherwise, due process rights are violated. Evidence is viewed in the light most favorable to the jury's verdict. And the jury's verdict in this case basically rejects the aggravating factors that the sentencing judge found. I welcome the court's questions.
Can I go to the specific unanimity? It wasn't requested, correct?
Yes, correct.
How is this situation different from Chase? In State versus Kyle Chase, the 2023 case, we said that when there had been a conviction of the aggravated assault based on strangulation, actually it wasn't domestic violence aggravated assault, it was a simple aggravated assault based on strangulation, and a misdemeanor domestic violence assault, that because the misdemeanor could have been based on exactly the same act as the felony, we know that they unanimously found at least 1 incident of a domestic violence assault, and that was good enough. Essentially, that's what we said in Chase. Clearly, it would not have been error to have given a specific unanimity instruction here. The question is whether it's required. Why is this case different from Chase? And I may have let slip why I think it might be different.
In Chase, the domestic violence case, the incidents underlying that offense did include a strangulation incident. So there, the court said that the jury must have found the defendant guilty of basically what they had already found him guilty of in the aggravated assault charge. Here it's totally different because the indictment granted does not specify any factual allegations, but
Well, the facts were included, at least evidence of strangulation in this case as well. And isn't that the basis for the count 2, the domestic violence aggravated assault?
are we talking Chase or are we talking?
No, here in Valeriani.
Here, the aggravated assault case only included strangulation. The evidence presented at trial included a lot of instances of conduct, but at charge conference, in addition to the state's closing, that is not what was presented as the basis for the domestic violence assault.
Counsel, let me ask you this. Could the state have charged a domestic violence assault, straight assault charge, based on the strangulation?
They could have, they didn't.
Understood, but if the jury found beyond a reasonable doubt that Mr. Valeriani was guilty of that offense, then haven't they a fortiori found him guilty of the other offense?
No, because both at the charge conference.
But was there a special verdict form? Was the jury given a special verdict form?
No, they were not.
It was just yes or no?
Yes, they were
Guilty
not.
or not guilty?
They were not given. At the charge conference and as well as at the closing. And at the closing, the basis, as they put it to the jurors, was 3 incidents that my client allegedly pushed the complainant into the sink.
But that's just simply argument on the state's part, is it not? The jury heard the evidence and they determined whether or not the elements of the charges as have been described to them by the court, whether those elements have been met.
I respectfully disagree because that is not what the juror at the closing was presented with.
Well, wasn't the prosecutor very clear in the closing? Count 2 is the strangulation incident. Count 5 is the sink incident. It was pretty clear. How would the jury get confused?
Our contention is that the jury was clear about what aggravated assault included. That was a single incident of strangulation. But on domestic violence assault, they were confronted with 3 different incidents.
But all we need to know is that they had to, the whole idea of a specific unanimity instruction is that they must agree on at least one incident occurred. They don't have to, doesn't matter which one though, they had to agree on one. And since they had convicted him of the Class B DV aggravated assault, we know they unanimously agreed on at least one incident. Why isn't that good enough for the Class D DVA?
Because the state made a distinction between the incidents. That is simply why. And it was very clear at the charge conference that the strangulation incident was not a basis for the domestic violence assault.
In the state's view. But we have a general verdict here because there wasn't a specific unanimity. So our question is, sure, it probably should have given a specific unanimity instruction. So then the question is, but they didn't, so how do we analyze it? And if we know that the jurors did in fact unanimously agree, and this is what we said in Chase, that they obviously unanimously agreed on at least one incident, the one involving the strangulation, despite the allegations of all the other things, isn't that good enough to sustain the verdict in this instance?
No, it's not. Our case was more nuanced, and it was not a strategic decision on part of the defense. It was not an all or none defense.
I think in Chase, though, that there were some of that, too.
Exactly.
So.
In Chase, it was kind of an all, it wasn't totally, but ours, as I said, was more nuanced. And the jury left the courtroom in the absence of any unanimity instruction, with what the prosecution...
Well, there was a general unanimity instruction provided by the court, correct?
Yes.
Okay.
Can you explain why this was not an all or nothing defense? Because in Schooley we said, either the jury believes all of what the victim said or none of it. You're saying that this is different?
Yes, in Schooley it was, I make a distinction basically because in Schooley it was a longer historical kind of period of time. Whereas here we have at most a couple of hours, and that is not even continuous. In Schooley it was a denial. None of it happened. Here, my client never alleged that none of it happened. Specifically on count 5, there was a self-defense instruction. And as we know, the jury returned a not guilty on everything, including the machete incident. So credibility was a main issue, and by the mere fact that the jury rejected the underlying facts, making up those two not guilty counts, it's quite clear that they did not find the complainant reliable on those charges.
Perhaps they did on everything other than the allegation of the strangulation.
They did believe him. They did believe her on the strangulation incident, and that
does that suggest that perhaps that was the basis upon which they agreed on a unanimous perspective?
No, for the same.
The assault.
No, because again, that was not in the charge conference, and that's not what the jury left the courtroom with.
So, counsel, our cases on specific unanimity typically involve situations where there are multiple incidents committed over a period of time, all lumped into one charge. Here, it's one incident, one criminal episode, one victim, and a couple of possible ways to commit that offense. And haven't we said in other cases that the means of commission can vary? Jurors don't have to agree on the means of committing that crime in a particular incident. That's not a specific unanimity issue, is it? At least that's not the way we have applied it.
The jury does not have to agree with every single detail in the state's case. Agreed. What they do have to agree unanimously is which incident exactly are we
All right, so
talking about.
take this situation. It's an assault. It occurs twice, 10 minutes apart. 6 jurors say, I think it happened in the first incident, the first assault. And 6 say, no, I think it happened in the second. But they all agree that there was offensive physical contact committed intentionally by the defendant. Is a specific unanimity instruction required there?
I think yes, if depending on
What's your authority for that? Have we ever said that anywhere?
It has to do with the facts. It's different if I shove you into a wall or if I just push you downstairs.
Why? Why is that different?
They include, in our case, they include different times, different facts, and different circumstances. It's not just one single episode of half an hour of assault. No, the victim took her time, went outside, without her glasses. I don't want to specify those facts. She never called the police, and can I finish?
Yes.
I lost my thread of thought.
That's okay.
I just rest.
Do any of my colleagues have any additional questions they wish to ask?
Can I just ask you briefly about sentencing? We haven't talked about that.
Absolutely.
As you know, we've created a bright line between two types of appeals on sentence. Direct appeal, where we look only at the legality or illegality of the sentence on the face of the record. And then the discretionary appeal, which allows challenges to the court's findings and how it addressed the sentence. In this matter, I see that you argue that the sentence is illegal on its face because the court erred in finding multiple aggravating factors not supported by preponderance of the evidence. In other words, a challenge to the court's findings. And in Murray Burns, we said, an appeal of sentence on direct appeal challenges only the court's findings with discretionary determinations, the appeal will be dismissed. It seems there's a door that slams on that particular argument. Do you disagree?
And that don't rest on my brief, respectfully.
Oh, okay. All right. No, that's fair. That's completely fair. I'll just continue my questions.
Thank you.
Any other questions from my colleagues? Thank you. Go ahead.
No, sorry. On another point, just to clarify, you suggest that there's an excessive sentence here. But to the extent that the ultimate sentence that was imposed was basically less than the maximum for a Class B felony, do we arrive at any inference of this being disproportionate?
Because of the aggravating factors that have no basis, in fact, because of what the jury had already not found my client guilty of. So it very drastically lowers the bar. And in comparison with other cases, an 8-second...
Well, do we compare other cases before we've made a determination as to whether or not we think there's some disproportionality?
There is disproportionality because other cases had more severe, drastic facts.
Thank you.
Thank you.
Attorney Thomas?
Good morning, Chief Justice and Associate Justices, and may it please the Court. A unanimous jury found Erik Valeriani guilty of domestic violence assault and domestic violence aggravated assault. At trial, the state presented evidence that on the night in question, Valeriani and the victim got into an argument. He began thrashing her around in an attempt to get her phone. Her phone was lost in the struggle, and he took her glasses. He pushed the victim into shelves, resulting in a suspected concussion. He pushed her into the bathroom sink, which caused an elbow injury, and he strangled the victim. The state additionally presented evidence that on this night, Valeriani destroyed property around the house with a machete and jabbed the victim in the leg with a machete. The jury ultimately returned a verdict of not guilty on the charges involving a weapon. Valeriani was found guilty of domestic violence aggravated assault and domestic violence assault. Based on the evidence presented at trial and the jury instructions that were given, the jury clearly found Valeriani guilty of aggravated assault based on the strangulation. There's no other straightforward basis for the jury to find Valeriani guilty of aggravated assault but for unanimously agreeing on the strangulation. The factual basis for the domestic violence assault conviction could be several distinct instances of assaultive conduct, including the strangulation. The question of unanimity has been answered here. The jury found Valeriani unanimously guilty of strangulation. Under these circumstances, the specific unanimity instruction is not required. Appellant additionally appeals his sentence. However, the sentencing review panel denied appeal, which constrains this appeal to the legality of the sentence, not the propriety. When the lower court sentenced Valeriani on these charges, it took into account information and evidence that it derived from the sentencing hearing and from trial. The court did not consider any information or draw any conclusions that were illegal. Therefore, this court should affirm Erik Valeriani's conviction and sentence. If the court has any questions, I would be happy to answer them at this time.
So it sounds like you're basically going along with what I suggested, which is this is State versus Chase, where there's an aggravated assault and then a Class D domestic violence assault. And since we know they found unanimously the strangulation, that would also support count 5 in this case. Is that what you're suggesting?
Yes, Your Honor.
That they unanimously found that?
Yes, this case is essentially the same as State v. Chase in that respect.
But there's one difference, and that is that in Chase, he was charged with aggravated assault, not domestic violence aggravated assault. Here it's domestic violence aggravated assault. So in Chase, it was suggested actually even by the state that that is true, that the count 5 could be supported by the same incident, but that they needed to be merged, and we said no, because domestic violence assault is not a lesser included offense under the Blockberger test of aggravated assault. However, it is a lesser included offense of a domestic violence aggravated assault, isn't it?
It is, yes.
So do we need to merge them in this case as a remedy? Since that's the only incident that we know for sure they unanimously found him guilty on.
So I think if the court decides to take up the issue of merger, then yes, the charges would need to merge here. Under the Blockberger test, which looks at the elements of each charge and determines whether one charge has an element that needs to be proven that isn't present in the other charge and vice versa. Looking at the charges here, since they both charges have the domestic violence element, the relationship element, the charges would require merger.
So follow chase, except it's merged instead of not as it was in that case.
Yes, that's correct.
Was the sentence stayed here?
No, the sentence was executed.
So has the 364 sentence already been served?
Yes, at sentencing, in fact, I believe the defendant had been in custody for about 15 months. So when the court sentenced him to the 364 days straight concurrent, that entire sentence on the domestic violence assault charge had pretty much already been served at that time.
He was given credit for time.
Yes.
Yeah.
There don't appear to be additional questions.
Well, there is one question.
Okay.
In looking at the transcript, am I correct that the sentencing judge actually sentenced the defendant on counts 1 and 4 as opposed to counts 2 and 5? And if that's true, is that a problem?
I didn't notice that in the transcript. I believe it was everyone's understanding at the sentencing hearing that he was being sentenced on the aggravated assault count 2 and the domestic violence assault count 5.
I agree that's reflected on the J&C, but it seems to be inconsistent with what the judge said at the time of sentencing.
I would have to go back and look at that. I'm not sure. And since it's reflected in the JSC, I think the sentence here would stand.
And that's what the jury found was counts 2 and 5.
That's correct, yes.
I don't want to cut anybody else off.
All right,
Thank you, counsel.
If there's no further questions, the state rests. Thank you.
Attorney Ganji, you reserve 3 minutes for rebuttal.
I'm afraid I have nothing further to add, but I also did not have a memory of that, I'm afraid, that inconsistency.
And do you have any argument about whether or not the domestic violence assault should be merged in with the aggravated domestic violence assault?
I think there was discussion in chambers, and counsel would correct me if I'm wrong, that the issue of merger was discussed. And both parties decided, as the court suggested, that this is not a case that would require a merger.
Well, does the domestic violence aggravated assault include the prospect that one offensive physical contact is part of the definition?
Yes, yes, I agree. I agree in the sense that there is an argument for the merger.
Do you think that the domestic violence assault is a lesser included offense under the Blockberger test of a domestic violence aggravated assault?
Yes. In case there are any further questions.
I think we're all set. Thank you. Thank you, counsel, for your argument here today. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. I also understand for both Attorney Ganji and Attorney Thomas, that this is your first appearance here in front of the court, and as our custom is to have you come back into our conference area and take the greetings of the court, and we welcome you to do so.
All rise.